this training again if needed. And in order to avoid technical problems as much as possible, please turn off your microphones and cameras. So you can, of course, ask questions using the chat during this training. So Maître Saettel will answer all of your questions. And another information for another APL event in a few weeks, a visit to the House of BioHealth will be possible for our members. We have a limited numbers of places, so you will receive an email today for more details. So it will be possible for you to visit the House of BioHealth and to see different presentations. So we will have the possibility to participate in this event soon, and you will receive more details. Thank you very much. And now that we have 30 participants, we will begin soon. Thank you.
Thank you, all of you. So the topic of today is the Bill 7383, and it's important new project for the health and regulatory in Luxembourg. We have the pleasure to have with us Camille Saettel, attorney in law in Luxembourg. Camille is partner at Thewes Reuter. Thewes Reuter is the well-known Luxembourgish firm in Luxembourg. She had some more skills on IP, healthcare, and regulatory affairs. She did her master research degree on fundamental European law. She's also members of the Luxembourgish bar, and you know her as well due to the book on drug law published in February 2021 by last year. You can find all the details of this book and also her intervention about reimbursement with Claude Frieden from CNS on APL YouTube channel. Camille, it's your turn to start. Thank you for being here and for your work to explain us the new Bill 7383 that you can find also on the Chambers of Deputy on the Luxembourg website. Thank you, Camille. Floor is yours.
Well, thank you, Sonia, and thank you, APL, for your warm welcome. Thank you, everybody, for your interest and for attending this presentation of a very technical project law. Some projects are easier to understand than others. This one is particularly technical and not really very easy to read. Why is it so technical? Because it addresses topics which are themselves technical in nature, such as manufacturing of medicinal products, off-label use, and etc. This project of law goes into the very detail of these topics. So if you want to understand the project of law, you need to have a full understanding and a full knowledge, a good knowledge at least of the topics themselves. And thirdly, the project has been disrupted, at least the legislative procedure of the project has been disrupted by the COVID crisis, and this COVID impacted both the content of the project of law and also the duration of the adoption of this project. And I will come back later on that aspect. And since we are in the introduction phase, I will also say a few words on the purpose of the law to give you a global presentation of the law. This law intends to clarify into the law, with the legal certainty of the law, some already accepted practices, such as off-label use, compassionate use, that in some extent were already accepted were already done in practice, but without a formal and explicit regulation. And this lack of regulation could give rise to issues, notably on the question of the liability for the healthcare, for the doctors, etc. So it was very important to have a complete legal framework for that question. And I think this is the most important aspect and reform of that project of law. Secondly, this law also regulates some activities. So it's complete new regulation on some, for example, regarding the distribution of medicinal products, and also, for example, the importation and manufacturing of active substances. So there is complete new provision on that aspect. And lastly, the project of law also fixed some residual inconsistencies in the law, because as you know, the law regarding medicinal products, the global regulation on medicinal products is composed of a lot of laws, and there could be some inconsistencies between all of them. So this project of law aims to fix that, and it fixes also some lack of legal basis, because as you probably know, the regulation on medicinal products deals with an economic activity. And according to the Constitution, and that's a very technical aspect, but I will try to summarize it. According to the Constitution, an economic activity needs to be governed by the law and not by a grand-scale regulation. And some of the activities regarding medicinal products were governed by a regulation. And that's why this project of law sometimes try to fix it and to give a legal basis with an express provision directly in the law.
Camille, before continuing, I would like to share a pool to know what our members are looking for. So I will share some more pools during this session. The first one is about the content of the bill, and I would give you 1 minute to answer if you have already read the bill 7383, and what is the more important topics for you. It could also be important for Camille to know what are the main topics for everybody. So some more time. Yes, so I will stop the pool. It seems that most of our attendees doesn't have read the bill, 79%, and also 18% has only read some certain points regarding the bill. And the more attractive point is distribution to the public. Yeah, and market access also. So the two main topics for our members seems to be distribution to the public, market access, and importation. I will let you continue.
Okay, thank you, Sonia, for this okay, then I can see the results. That's a very interesting survey, so I can understand that most of you didn't read the project of law. That's why it would be important to have a global and complete overview of that project of law. I will try to give only a light touch on two technical aspects. So, but we will need to run into the whole complete project of law.
And we have also a first question, Camille. It's can you clarify, is the law result in practical difference between Belgium and Luxembourg?
I did not perform a comparison between both laws, but from what I know, I know that some provisions are inspired by the Belgian regulation, notably on the question of compassionate use, compassionate program. I think that this is in a large extent inspired by what is applicable in Belgium.
Thank you, Camille.
Okay, then let's start with the presentation of the law. I will suggest to structure my presentation around two parts. The first one will concern a description of the legislative procedure to let you understand to let you have an estimate of the time frame for the adoption of the final law, and to understand why is it such a difficult to read project of law. And secondly, we will go into the content of this draft bill. So let's start with a description of the legislative procedure. It's important to understand that this is still a draft bill in progress because an initial project has been submitted to the Chamber of Deputies in October 2018. Then a few advice were issued from Medical College, Chamber of Commerce, le Syndicat des Pharmaciens Luxembourgeois. It is a retail federation of pharmacists. And also the most important is the advice of the Council of State. Then after that, in November, so almost 1 year later, in November 2019, the government issued an amended version of the law, who takes into account the observation made in this advice. After this amended version, a few advice were again issued, again from the Chamber of Commerce, Medical College, also the CNPD, which is the Commission for the Data Protection, and also an advice from the Ethics Committee. And today we are still waiting. I don't say that they are late, but we still need to receive the advice, the second advice of the Council of State. This advice will control that the recommendation set out in the first advice were correctly followed by the amended version, and the Council of State will very likely make new comments, new recommendation that will very likely and very certainly give rise to a new amended version. But today we only can work on the base of this amended version dated of November 2019. Regarding the content, it's also important to understand that it's a moving content. Why? Because since November 2019, the project of law, as well as the whole world, was hit by the COVID crisis. And after this sanitary crisis, the government, through emergency proceeding, adopted in June 2020 and July 2020 two laws trying to give remedies to this sanitary crisis. And of course, containing provisions on the supply of medicinal products and provisions affecting the regulatory of medicinal products. And some of these provisions are already passed into a law, and this is, for example, the storage of medicinal products, like the dépôt de médicaments, or a provision regarding international health crisis, were contained in the amended version, and they passed into the force of law thanks to this law of July 2020. That's why there will very likely be an amended version that will at least clean the version and withdraw the provisions that have been adopted in July 2020. And last information regarding this procedure, it's in order to have to forecast the time frame for the adoption of the final law. So like I said, today we are still waiting for the second advice of the Council of State. Then we will very likely need to wait until a new amended version. Will it be the final version or not? We don't know it yet. But there will also be a need of execution act. It's a Grand-Ducal regulation, because the law will need to be executed by regulation. And usually this Grand-Ducal regulation is analyzed and adopted at the same time as the law, but we don't know if they already exist or not. And they will also, but that's my opinion, very likely be a modification of other laws that may be impacted by this project of law. So for the forecast of the date of adoption of the final law, it will not be before the end of this year, and we hope in 2022, because I know that some provisions are highly awaited by the industry and the professionals of the sector. So this final law is highly awaited. I hope I was clear enough regarding this first part, the description of the legislative procedure. And I will start now with the concrete content of the draft bill. And as I said, we will work on the last amended version. Since some of you probably read the initial law that was submitted in October 2018, I will just say a few words on the comparison between the initial version and the amended one. The initial law was composed of 3 articles, when the amended version is much more structured, organized around 8 chapters, and the amended version contains 37 articles. So there is a more complex structure, but which makes the law easier to read. There are also new provisions amending a Royal Act on Service Medical, the law on medical devices, and the law on the profession of pharmacists. And I will also say, that's my opinion, that both projects share the same limit, which is the lack of comments, because as you know, each project of law is accompanied of comments, explaining comments from the author of the project, explaining the motivation, the rationale, and who give explanation on how it would be applicable in practice. And in my opinion, the comments are a little bit light on some specific topics. And that's not helpful for us today when we are trying to analyze this project. So this amended version modifies several laws, 7 laws in total. We can see on this scheme that several topics are concerned, such as manufacturing of medicinal product, importation, distribution to the public, market access, medical devices, profession of pharmacists, and wholesale distribution. So today we will go into each topic one after the other. So let's start with...
And I will come with a new pools on each topic. So I would like to know, I guess that's your answer, but I would like to know if you are active in manufacturing and if you are familiar with a manufacturing law in Luxembourg. So I let you a small time to answer. I will maybe let you a couple of seconds more. Yeah, I think we have enough to share the answer. So as you can see, most of you are not active in manufacturing and not familiar with this topic. So it's a good insight for Camille to continue her presentation. Thank you for answering the poll.
Manufacturing of medicinal products is governed by a law of 1975, which has been amended since its adoption, of course. Regarding manufacturing, the project of law makes 3 main modifications. The first one concerns the price of products made by pharmacists. The second one concerns the manufacturing of medicinal products, and the third one concerns manufacturing of active substances. So let's start with the price of products made by pharmacists. To understand the modification, I need to explain that in Luxembourg, the price of medicinal products are approved by the ministry in charge of the social security. This is provided by Article 22 ter of the Social Security Code. Sorry for that. And according to that article, so the decisions regarding the price of medicinal products for human use, with exception of preparations made by pharmacists, are issued by the ministry in charge of the social security. So what do we learn from this article is that the price of medicinal products falls within the hand of the ministry in charge of the social security when, sorry, you cannot read, okay, when the price of the preparations of the pharmacist remains in the hands of the Ministry of Health. So this distribution, it's important to understand this distribution. The project of law withdraws an old legal basis for the price of medicinal products, which was contained in a very, very old act at Article 36 of the Royal Act. So this legal basis is obsolete today, since there is Article 22 ter of the Social Security Code. That's why this project of law withdraw this old legal basis. And regarding the products made by pharmacists, today there is no express legal basis, because if you remember, it's only, I come back to Article 22, it's only an exception set out in this article. with exception of preparations made by pharmacists. And in practice, the price of the products made by pharmacists are only governed by a regulation dated of 2012 on the price of products prepared in pharmacy, which is called in French préparation galénique. And as I explained at the beginning of my presentation, this is the regulation of an economic activity which needs to be regulated directly in the law. So there were a lack of legal basis in the law, which is fixed by this project, which had a new legal basis at Article 3 of the law regarding manufacturing. And this Article 3 concerns in details the price of the products made by pharmacists. And this mainly concerns the retail distribution of medicinal products. Secondly, regarding the manufacturing of medicinal products, as you know, the manufacturing of medicinal product is subject to a prior authorization of the Ministry of Health. This is provided by Article 3 of the law on manufacturing. They already exist, one exception for pharmacists manufacturing in their pharmacy. This concerns a magistral formula, official formula, or the reconditioning for medicinal products, which are not subject to an authorization for the manufacturing. This project of law completes that provision with a second exception for blood and plasma delivered by a blood transfusion organism by a non-industrial process. And thirdly, regarding manufacturing, there is a modification of the legal framework of the manufacturing of active substances. First, what is the manufacturing of active substances? The law, the project puts a definition directly in the law. It covers both total and partial manufacture or import of an active substance, which is used as a starting material, and the various processes of dividing up, packaging, or presentation prior to its incorporation into a medicinal product. This definition is a literal implementation of the definition contained in the directive regarding medicinal products. And what is new in the law, in our Luxembourg law, is the obligation to notify the manufacturing of active substance when it is manufactured by a manufacturer having registered office in the Grand Duchy of Luxembourg. And the conditions to meet are not provided by the law, and that would maybe and need to be completed in the amended version, I don't know. But today, the conditions to meet to be authorized to have the right, at least, to manufacture active substance, the conditions are governed by a regulation dated of 2004 on the manufacturing of medicinal products. There is one article, which is article, I will let you see, Article 7 bis. So, yeah, yes, I give you.
Yes, I'm here again with the third survey about importation, and always the same question. Are you active in importation, and are you familiar with importation? So I let you answer. Yes. I'll let you a couple of seconds more. Nobody answer more, so I will stop and share the results. Yes, about the activity in importation, most of our attendees doesn't have activities in importation with close to 80%, and familiarity is quite the same figure. So thank you for answering this short pool.
Okay, well, importation is a real subject here in Luxembourg because we don't have yet a local production of medicinal products. So importation is a real concern here in Luxembourg. So it is governed by a law dated of the same law that manufacturing, the same law of 1975, amended since its adoption. And regarding importation, the project of law modifies the framework of the importation of medicinal products and active substances. We will see the common provisions for the importation of medicinal products and active substances, and a common provision to the manufacture and importation. This will help us to fully understand the legal framework. So regarding importation, I will explain the way of the adoption of the provision today. Importation was previously governed directly in the law at chapter 3 of the law regarding manufacturing. But in 1995, the provision regarding importation were withdrawn by this law of January 1995 regarding wholesale distribution, and importation was subject to wholesaler authorization, because, as you know, wholesale distribution is subject to an authorization issued by the Ministry of Health. And the legislator in 1995 decided that importation and wholesale distribution was in practice the same activity here in Luxembourg, and that they should be subject to the same condition of exercise, and then importation was subject to a wholesale distribution authorization. And today, with this project of law, the legislator come back to what was previously in the original law in 1975, and decide to set up again an authorization for the importation of medicinal product directly in this law regarding manufacturing and importation. So what is an importation? It's any operation having the effect of introducing into the territory of the Grand Duchy of Luxembourg medicinal products or active substances. So as you can understand from this definition, importation, there is an importation regardless of the origin, outside European Union or inside European Union. It concerns also pharmacy open to the public as well as hospital pharmacy. That means it's not only for a commercial purpose, and it also concerns medicinal product as well as experimental medicinal product. And we will see there is an exception for the personal use of medicinal products. So what is it in detail? There is a modification of Article 6 of the law, which states that importation of medicinal product from a country outside the European Economic Area is subject to an authorization issued by the Ministry of Health. So in practice, it's only importation from a country outside the European Economic Area, not inside the EU. There is an express exception for medicinal product for personal use, which is defined by the law as any determined quantity of medication prescribed for therapeutic use, either for a duration of treatment not exceeding 3 months, or of the duration of treatment specified by the medical prescription. In that case, there isn't any authorization required. There is a tax also to be paid, and the authorization should be granted if all the conditions are met within 90 days from the filing of the application. What are the conditions to be authorized for the importation? Of course, there are conditions related to the premises. There is an obligation to have a full-time responsible pharmacist approved by the minister. Regarding the supply chain, there is all the usual conditions to control the supply chain, that the importer can only import medicines from person authorized to either manufacture or to perform the activity of wholesale distribution, and the importer will only have the right to supply medicinal product to persons who have a manufacturing authorization or a wholesale distribution. There is an obligation for the traceability, and of course you need to provide proof of payment of the tax, and sorry, I lose my and there is also a provision in the case of experimental medicinal product. You need to specify the manufacturing process. And there is also the law directly regulates all the information that had to be registered in the application for the authorization. I will not read them in detail, but what's important is the obligation to have an authorization of establishment granted by the minister having the middle class in his attribution. So this is a step that should not be ignored when you set up an activity for importation. It's usually fast in practice, but it's important to bear in mind that such an authorization is also required. And there is also all information regarding the responsible pharmacist to be registered. So that's all for the importation of medicinal product. And what about the importation of active substances? This will be governed at the future Article 7 of the law, which will state that importation of active substance is notified by the importer having registered office in the Grand Duchy of Luxembourg. So it's not an authorization, it's only a registration. Importation of medicinal product is subject to authorization, when importation of active substances is only subject to notification. There is again a tax to be paid, and it's important to know that the activity of importation of active substances is subject to the European GMP, Goods Manufacturing Practices. What are the conditions? The law requires, the project of law requires that the active substances have been manufactured in accordance with standards of good manufacturing manufacturing practice, at least equivalent to the European one, and that the active substances are accompanied by written confirmation from the competent authority of the exporting third country, certifying that the standards of good manufacturing practice applicable to the establishment which manufactures the exported active substance are at least equivalent to the European GMP. Secondly, that the manufacturing establishment concerned is subject to regular, strict, and transparent controls. And we will see that there is exception to that, to the certification of regular, strict, and transparent controls. And thirdly, there is, it's mandatory to confirm that in the event that a non-compliance is found, the information regarding to this will be immediately communicated to the European Union by the exporting country. Let's see the exceptions provided by the law. Exception to the obligation of being subject to a regular control. Condition B shall not apply if the exporting country is included in the list of third countries. The third countries referred to in article in the directive, article 111, which allows the Commission to assess whether that country's regulatory framework applicable to active substances exported to the Union and the respective control and enforcement activities ensure a level of protection of public health equivalent to that of the European Union. And exceptionally, and where necessary, to ensure the availability of the medicinal product, when an establishment manufacturing an active substance for export has been inspected by the Direction of Health and was found to comply with the principle of guidelines and GMP in the EU, the Ministry of Health may waive the obligation of regular control. So there is a competence of the Direction of Health to inspect such establishment. Regarding the notification, it has to be before the beginning of the activities, 60 days before the activity. And within this period of time, the Director of Health can notify an inspection and without any notification of such inspection within this deadline of 60 days, the applicant is authorized to start its activity. So this is what we call an implicit authorization. So just to come back to what I explained, so to keep you to remember you the rules. Importation of medicinal product is subject to authorization when importation of active substances is subject to registration. But both are have common rules, such as the obligation to appoint a responsible pharmacist, which is in charge of the permanent surveillance of the importation. This responsible pharmacist, there's nothing new. He needs to be approved by the minister. He can only offer services to one importer only, and he is prohibited from managing a pharmacy open to the public or to be employed in such pharmacy. And of course, the ministry controls and can withdraw the approval in the case these conditions are not fulfilled. What else? The examination of the request, the application form for authorization and the notification are subject to a report issued by a pharmacist inspector of the Directorate of Health. There is an obligation to notify any modification in the information submitted to the Ministry of Health for the authorization or the notification, and the Ministry, of course, has the competence to modify the authorization or to perform an inspection if necessary in the case of active substances. And since we have two legal framework for importation and manufacture, I also tried to summarize the common rules to both activities. So there is the same requirement regarding the supply chain, manufacturing or importation authorization holder for medicinal products, as well as the manufacturer or the importer of active substances can sell, offer to sell, or transfer medicinal products only to persons authorized to sell or to distribute medicinal products or active substances. And of course, there are sanctions in the case where the provisions, the legal provision, are not followed in the case of if there is a breach in the law. But what I noticed that there is, in my opinion, no sanctions for the manufacture or importation of active substances, because all the sanctions concerns the authorization. Maybe something is missing on that point. And to finish on that topic on importation and manufacturing of medicinal products and active substances, I would like to draw your attention on a few points, but it's only my advice, and of course this will need to be confronted to the last amended version, because I'm pretty sure there will be adjustments to be made in the last amended version. But there is firstly a potential conflict with the provision on wholesale distribution, because as I explained today, in the current and applicable law at that time, importation of medicinal product is subject to wholesale distribution. And since the law, the project of law, places the importation under the importation authorization, there is a need to withdraw the provision in the wholesale distribution law. That's a technical aspect, but if we need to, the legislator need to avoid the risk of inconsistency in the law. Second observation that I will make is that the legal framework for manufacturing of active substances seems, in my opinion, to need to be strengthened, because there is only one legal provision and formally one provision in a Grand Ducal regulation, and that may be a little bit light for an activity which is not without risk. Manufacturing, of course, needs to be strictly regulated. And thirdly, there is a superposition of different legal framework for the manufacturing importation, which are governed both by the law and the regulation, so it's not easy to read. And I also raise the interrogation of the necessity of this dual legal framework regarding one, importation, second, manufacturing, because in the European directive, importation and manufacturing are subject to the same authorization, unless I'm mistaken. And even the legislator himself, in the comments of the law, state that the distinction between manufacturer and importer is superfluous, since the import activity implies that any person carrying out this activity is considered to be an importer, whether he is a manufacturer, wholesaler, or other comments. See the comment on Amendment 12. So that's for you, professional of the industry, to think of maybe a way to adjust the project law today, if there is a space, a room for the government, for the ministry in charge of this project of law to receive advice and consideration from the industry. Okay.
Before starting, the next topic will be one of the more important, as we have seen in the pool. I would like to send a new pool survey for you. Always the two same question: are you active in distribution of to the public, and are you familiar? So it seems it's a really important topic for most of you, I guess. No, start with 100% yes, but now it's moving. Yeah, so we still need 11 votes. So I will stop and share with you the results. It seems that it's quite equal attendees with activities in distribution to public and not. It's important for Camille as well. Thank you.
Yeah, yeah. The answer is consistent with the first survey, so it's a topic for which you have a strong interest. So the distribution to the public is governed by the law of November 1975, which has been amended since its adoption. And regarding this topic, the project of law makes 3 modifications. The first one concerns the adaptation of the principle of the exclusive distribution of medicinal products by pharmacies open to the public. The second one is a technical modification regarding the distribution through internet. It's nothing very consistent on that aspect, but we will look at it. And thirdly, there is a provision regarding the storage of medicinal products, le dépôt de médicaments. But as I explained at the beginning of my presentation, this is one of the provisions that have been adopted, passed into the force of the law, thanks to the law of July 2020. So the provisions regarding the storage of medicinal products are still in the law, but in the project, but they already are applicable. So regarding the first point, the adaptation to the general principle of the distribution to the public in pharmacies open to the public. This principle is contained at Article 3 of the law, and in its a principle to which the country is firmly attached, that the medicinal product, it's a principle, medicinal products are only distributed to the public from pharmacy open to the public. There is a monopoly on that side. But this project of law introduced 4 new exceptions to that principle, and we will look at these new exceptions. So there already exists one exception for the pharmacist, since they are authorized by the law to deliver medicinal products to persons accommodated in seniors establishment. This already exists. And the new exception provided by the project of law is will allow the pharmacist to deliver medicinal products directly to people at home. Second exception, so this is a derogation from the general principle set out in paragraph 1. The delivery to the public of compound health products, which is in French, produits de santé composés, may be made by authorized wholesalers who act under the responsibility of the responsible pharmacist. And since this is a tricky point, the list of compound health products will be set by a ground-ducal regulation. So they won't be allowed to distribute, wholesalers won't be allowed to distribute every medicinal products that are authorized for the commercialization in Luxembourg, but it first only compound health products and products that are listed in this ground-ducal regulation, that will be listed in the ground-ducal regulation. That's why, as I explained at the very beginning of my presentation, ground-ducal regulation are absolutely necessary for the execution of that law. So there is still some work to perform for the ministry, for the author of that law before its final adoption. There is a new exception for under the responsibility of a pharmacist for the distribution within the premises of the organization authorized by the minister to collect blood and plasma of preparations of medicinal products derived from human blood and or plasma collected by the organization on its premises. This is very likely already the case in practice. I'm not sure, but I will assume that this is the case in practice. And this provision is very likely more a provision that gives legal basis to an already existing practice, but unfortunately, there is no specific comment on that topic, so I cannot control if I'm correct or not, if I'm right or not, but I suppose this is the case. And the fourth exception is the possibility to, under the responsibility of a pharmacist, to deliver medicinal products to the patients of an establishment authorized to perform voluntary terminations of pregnancy. And again, the limited list of products will be set by a ground-ducal regulation. There is an observation that comes from a cross-reading of all law applicable, and especially Article 4 of the law regarding the distribution to the public and the storage of medicinal products. I will come back to the question of the storage of medicinal product, but as you may know, the storage of medicinal product has been allowed in its establishment authorized to perform voluntary termination of pregnancy. So it has been authorized by this famous law of July 2020. And according to that law, this establishment authorized by the law are only allowed to get the medicinal product from a pharmacy open to the public. So what's the consequence? I tried to make a draw on the situation of the distribution to the public of medicinal product. So there is an additional competence for the wholesalers for compounds product on one hand, but on the other hand, the pharmacist gains another an additional competence which allow him to distribute medicinal products directly to patients' homes and drugs for voluntary termination and of pregnancy. Okay, regarding the distribution through internet, so there is nothing revolutionary in that area. It's only a correction of a lack of legal basis. So, as you probably know, the distribution through internet is allowed. This is also one of this is one remarkable exception to the obligation to deliver to the public only in pharmacy open to the public. So there is a long, there is a few provisions in the law that regulates the distribution through internet, which is an activity which also needs a strict regulation. As you may know, there is a website from the Ministry of Health or the Direction of Health that in the website of the Direction of Health, sorry, that allow the public to control if the website is an official website authorized by the Ministry of Health. And there is the European directive provides that the member states are responsible for the information which appears on the website of the Direction of Health. And so there were a lack of legal basis on that aspect. So the project of law completes the law with a simple, very simple provision stating that a grand-ducal regulation will specify the information which appears on the website of this Direction of Health. So so there will be only one provision in the law, and the rest will be the responsibility of a grand-ducal regulation, which procedure is, as you may know, much more flexible than a law. And just to say a few words to the storage of medicinal products. So as I said, it was already adopted by the law of July 2020. And for the record, this law created several authorized storage for medicinal products. They are all listed in the law. It concerns hospital premises, seniors facilities, some establishments in charge of social activities, establishments authorized to perform voluntary interruption of pregnancy, state services, in French, services de l'État, also fireman services, le corps d'incendie national, and also the right for the doctors to keep what's say in French a trousse d'urgence, a first aid kit for doctors. Okay, maybe I suggest before we enter into the main topic of that law that we have a 5-minute break so that you can breathe and you can think of what I just said, and maybe come back with a few questions of what I just said before we go into a new topic.
So I suggest coming back at 10:15, and then we will have 7 minutes to rest before starting this important and maybe more longer topic about market access. See you in a couple of minutes then. So we will start in 2 minutes. So we are back. Thank you for coming back. And we have 2 questions, Camille, for you. 1 question and 1 comment. The first is a comment. Thank you for the first interesting part. And the second in the chat is a question. What about the Red Cross? Can they store and deliver medicinal products?
Okay, so so storage of medicinal products and delivery are different. So first, regarding storage, they could be authorized because maybe I can come back. Yeah, it was the last slide. So the authorized storage are listed in the law, and there is one which is establishment in charge of social activity. In the law, it's in the project of law, and it's organism active in the field of social, family, and therapeutical area. So the Red Cross may fall in one of these categories. So we cannot rule out that a Red Cross could be authorized. Regarding the delivery of medicinal products, I'm not sure unless there is a doctor authorized through the authorization to have this first aid kit, whose purpose is to allow the doctors to keep first aid medicinal product. I don't. So we need to have a complete list, but that may be antibiotics and I don't know, everything that could be useful for first aid, and maybe through that provision, doctors could be allowed to deliver medicinal products. So I hope I answer the question.
So before starting, the second very important part regarding market access, a new survey for you. Could you please help us to understand if you are familiar with these topics and if you are active in this topic as well? Thank you for answering. Let you a couple of minutes more, seconds, not minutes. Yeah. I will stop the survey, and 57% of you are active in about this topic, and also most of you are familiar with 62%. Thank you. Thank you very much for answering. Then you have an idea of the attendees' knowledge, but also willing to know more about this topic, which we found it's really important. It will be a long one, more since 1 hour. And if you have any question, please feel free to share on the chat.
Okay, thank you, Sonia, for this survey. So we will go into what is probably the most interesting part of the law. And I'm happy to see that you have knowledge in that field, so it will be easier to understand. So regarding market access, the law provides modification regarding prescription and distribution, especially for off-label prescription and prescription of medicinal product without a marketing authorization. So we will run into 6 points. The first one are the new definition provided by the law. Secondly, what is an medical authorization under the law, because there is a modification in that field. The third point concerns the exception to the marketing authorization for subcontractors in the field of repackaging of medicinal products. The fourth point will be the more detailed point because it deals with off-label and compassionate use. And we will also have a quick look at the provision regarding ex-officio authorization and the expert commission, which are also concerned by this project of law. So let's start with new definitions. When you have new provisions, you also often have new definitions because they are important for the legal certainty. So there is a new definition of medicinal product, off-label prescription, sanitary emergency, and serious cross-border threat on health. Regarding medicinal product, I will say a few words because I am surprised that the definition is not the same as the European definition. It's almost the same, but there is a difference. And I don't know if it's voluntary or not, if it will be fixed or not, but I'm just surprised for this difference. Regarding the definition of what is a manufacturing authorization under Luxembourg law. So current Article 3 of the law, so we changed the law, it's a new law, it's the law of 1983, which has also been amended since its adoption. This law governs the commercialization and the advertising on medicinal product. And Article 3 of this law states that the placing on the market of any medicinal product is subject to the granting of a prior authorization issued by the Minister of Health. So nothing surprising. You may all know this fundamental principle. But as you can see, the current version states that the authorization is issued by the Minister of Health, which is slightly restrictive, considering the number of European authorization and the fact that European authorization have a direct effect in Luxembourg, direct effect provided that there is a national number, but they have effect as if they were issued by the Minister of Health. So that's why there is a modification introduced by the project of law. And the future Article 3 will be the placing on the market of any medicinal product is subject to the granting of prior authorization issued by the Minister of Health or by the European Commission in accordance with the regulation on the centralized procedure. So it could appear like a technical provision, but it has its importance for the rest of the analysis of the law. Third modification of the law regarding the commercialization and the advertising of medicinal products. There will be a new article, completely new. It's not a modification, it's an addition, which will state that an exemption of the obligation to hold a marketing authorization for preparations, divisions, packaging or repackaging, insofar as these operations are carried out in a pharmacy open to the public or in a hospital pharmacy, which is already the case as we have seen in the law regarding the distribution to the public. What is new is that the law expressively states that when the repackaging is done outside a pharmacy open to the public or a pharmacy or hospital pharmacy by a subcontractor, because as you know, this activity can be subcontracted by the pharmacist to a subcontractor. So this subcontractor will not need to hold a marketing authorization, provided that these activities do not result in any modification of the medicinal product and that they are carried out solely on the basis of individual prescriptions, making provision for them. Regarding subcontractors, so the law makes clear that they do not need to have a marketing authorization, provided that the condition that I just read is fulfilled, but they remain, it remains mandatory for the subcontractor to hold a manufacturing authorization. This results from the law regarding, unless I'm mistaken, marketing authorization, manufacturing authorization. And in accordance, last condition, sorry, I let you read. In accordance with the regulation on the quality and safety standards to be respected by the pharmacist who prepares, divides, conditions, or repackages drug. So there is a ground-legal regulation which contains a lot of provision regarding the safety and the quality standards for such repackaging of medicinal products. So let's go into the question of off-label and compassionate use. So if we look at the question of off-label prescription, there will be, after the adoption of the project, there will be an Article 5 bis regarding governing and authorizing the off-label prescription for one patient. Off-label could also be authorized in the case of an international health crisis. This is written in gray. Why? Because this provision on international health crisis, which is in the project of law, has already been adopted by the law on July 2020. So I hope you are still following me. This provision on international crisis allowing off-label prescription already passed into the force of the law. But I mentioned it for the record. Regarding compassionate use, this means in the absence of marketing authorization, the project of law intends to complete the legal framework with one Article 5 ter regarding the prescription for special needs for one patient only, and Article 4 quater regarding the compassionate use program. So in that case, for a cohort of patients. And again, international health crises. In the case of international health crises, there is also a possibility to prescribe compassion, to provide to prescribe, medicinal product without a marketing authorization. So we will look at it in the details, but this was to help you to follow the distinction between first off-label, for which there will be one provision, and except it's international crisis, and compassionate use, there will be two articles and additional article on international health crisis. So we will look at all of this new provision, future provision in details. So first, let's start with the question of off-label use. Off-label use, as you may know, is the prescription of a medicinal product which is covered by a marketing authorization for specific therapeutic indication, but the prescription is made for a therapeutic indication which is not covered by the marketing authorization. That's why it's called off-label use prescription. And this kind of prescription, the legality of the validity of such prescription has been admitted by the European Court of Justice in two major case law. And the Court of Justice ruled that off-label prescribing is not prohibited or even regulated by European law. There is no provision which prevents doctors from prescribing a medicinal product for therapeutic indications other than those for which a marketing authorization has been granted. So there were no express rule in European law, neither in Luxembourg. We had no express rule, but it was an authorized practice, but without legal certainty and provision. So they were a real need of an express legal provision to set out the conditions to meet, and especially to distribute the and to deal with the question of the liability. So in the initial draft bill, some of you may have read the first proposition for the regulation of off-label use, but it was a kind of concept of off-label temporary authorization of use by the physician. I think this did not make a lot of sense, and this provision has been deleted in the amended version of the draft bill, because it was a kind of hybrid status between French ATU and off-label use. Because, as you know, French ATU is a kind of where there isn't any marketing authorization, so it doesn't make sense to have an ATU when there is an authorization, and that's why the amended version is completely new on the question of label use. So just forget what you read with the initial draft bill, and just focus on the new amended version, and that's what we will do. So in the amended version, the future article will state that by way of derogation from Article 3, so Article 3 is the obligation to hold marketing authorization, a doctor authorized to practice his profession in accordance with the law regarding the profession of doctor. This doctor will be called prescribing doctor. He may prescribe a drug that does not comply with its marketing authorization under the following condition, and we will look at each condition. First, the off-label prescription is authorized to meet the special needs of a medical nature of one patient. These special needs are based on exclusively therapeutic considerations and will follow an effective medical examination of the patient, according to which the prescribing physician considers essential to use this medicinal product for human use for therapeutical indications other than those for which a marketing authorization has been granted, in order to improve or stabilize the clinical condition of these patients. So the first condition is very strict. So it's off-label prescribing can only concern one patient, so not possible for a cohort of patients. There must be an effective examination by a doctor. The medicinal product must have been prescribed by the doctor as a result of an actual examination of his patients. And there must be special needs of the patients, and special needs, it's a concept that come from the European directive and that has been explained by the case law of the European Court of Justice. It applies only to individual situations justified by medical considerations and presuppose that the medical product is necessary to meet the needs of the patient. So this is the first condition to meet, and it shows in which case it could be allowed to prescribe a medicinal product out of the scope of the marketing authorization. Second condition, according to the product of law, is that the patient cannot be treated satisfactorily with another medicinal product with marketing authorization. Regarding that condition, I am a little bit surprised, and maybe I don't fully understand it yet. I would have say therapeutic need is not already covered by another treatment covered by an MA, because when we are talking about off-label use, it seems to me, maybe I'm wrong, but it seems to me not consistent to set the condition that there is not another medicinal product with marketing authorization, because we are not talking about absence of medicinal product. But let's see if there is a modification on that point in the possible next amended version. Third condition, very important again, is that the patient's prior consent. The patient, of course, need to be fully informed. There is, of course, an obligation of information from the doctor, but for that, in that case, in the case of the off-label prescription, the patient needs to give his consent in writing. So there will be probably specific form that maybe the IMMD will issue. I don't know how it will be executed in practice, but they should be a consent in writing. Other condition, there is no equivalent of the product. The prescription of the medicinal product that does not comply with its marketing authorization is not covered by the marketing authorization for an equivalent medicinal product having a marketing authorization for the same therapeutic indication, which is logical, the same active substances, the same dosage, the same strength, and the same galenic form. And what is important in this condition is that off-label prescribing can be used when there is no equivalent of the product, but also no commercialization, when the product is not marketed or is out of supply on the national market. So that could be a way to solve one of the recurrent issue we face here in Luxembourg, which is the procurement of medicinal products. One interesting point and what makes this legal provision necessary is the responsibility of the prescribed physicians. So the law expressly states that the treatment is carried out under the personal and direct responsibility of the prescribed physician. This prescribing physician needs to manage adverse effects, so he is also responsible in that field. Regarding the delivery of medicinal products, they could be delivered by a pharmacist from a pharmacy open to the public or from a hospital pharmacy on the basis of a prescription. This prescription needs to mention the inscription, the express prescription, prescription not in accordance with the marketing authorization, so that the pharmacist is informed that he is going to deliver an off-label use medicinal product and maybe may need to give specific information to the patients, and that also the pharmacist is informed that he needs to register, to record the prescription and the law says importation of these drugs in a special register kept for this purpose.
Camille, we have a question. If the question is, if I understand well, the physician needs to have a special insurance.
This is correct, and this is, unless I'm wrong, yes, the next condition set out by the law. The prescribing physician has a civil liability insurance that covers potential damage occurring in the course of the treatment. So so that also will require execution provisions, discussions with insurance, because I'm not sure physicians already has a physician's insurance already covers this specific case of off-label use, and this will probably need to be discussed with insurance. And I hope this won't take too long to set up a specific insurance in that field. So we finished with off-label use, and now we will talk about the prescription without marketing authorization. So the objective is to give the patient access to innovative medicinal products that are not approved yet, and to answer medical needs that are not covered by marketing authorization. So this is a very important provision for the patient as well as for the industry. When there isn't a marketing authorization, there is a current well-known, I think, Article 5 of the law on the commercialization of medicinal products. This Article 5 allows occasional dispensation of a medicinal product by the pharmacist in a pharmacy open to the public. And it concerns medicinal product covered by marketing authorization in its country of origin. So it's this article covers the case when there is no marketing authorization issued by the Ministry of Health, current definition of the marketing authorization, but there is a marketing authorization in the country of origin. This occasional dispensation is allowed in two cases. First, individual and nominative prescription for one patient, and also in the case of a collective prescription in a case of serious and urgent treatment in hospital. So current Article 5 covers and allows the importation of a medicinal product which is not covered by a marketing authorization in Luxembourg, in the case of an individual prescription or a collective prescription. This Article 5 should be replaced, will be replaced according to the actual version of the amended project of law. Article 5 should disappear. And what about the occasional dispensation for one patient and occasional collective dispensation? They will be governed by two future articles, Article 5 ter and Article 5 quater. So, as I said, the rationale for the interest of the prescription without marketing authorization is to provide patients with rapid access to innovations representing a major therapeutic advance or meeting an unmet medical need. So, Article 5 ter, so this is the prescription for special needs of one patient. This article basically implements Article 5 of the European Directive. He will replace current Article 5.1, which is what I just explained, on the occasional importation in the case of individual and nominative prescription. Regarding Article 5, paragraph 1 of the directive, European Directive, this article has been interpreted by a case law of the European Court of Justice, which ruled that it's a specific derogation provision which must be interpreted strictly, applicable in exceptional cases, to meet special needs. And there is a definition of special needs in circumstances in which a doctor, following an actual examination of his patients and on the basis of purely therapeutic considerations, prescribes a medicinal product which does not have a valid marketing authorization in the European Union and for which there is no authorized equivalent on the national market or for which is unavailable on the market. So how Article 5 ter is structured, there should be a first paragraph dealing with the absence of Luxembourg marketing authorization or European marketing authorization, but will require a marketing authorization issued in the member states, in another member state or a signatory member state. And there is a second paragraph governing the case where there is no marketing authorization at all, and this is an emergency proceeding. So let's start with paragraph 1. So the prescribing physician may prescribe a drug that does not have a marketing authorization to meet special needs of his patients, provided that, so same condition, the treatment meets special needs of one patient. So same consideration, one patient, effective examination, special needs. There is also an important condition that the prescribed drug does not have a marketing authorization within the meaning of Article 3, which is, remember, if you follow me, you will remember that Article 3 states that an authorization is either a Luxembourg marketing authorization or an European marketing authorization. So this article will apply in the case where the prescribed drug does not have such a marketing authorization, but a marketing authorization issued in the by the competent authority of another member state of the European Economic Area, or of a country who signed with the European Union an arrangement for the mutual recognition of good manufacturing practices. So this could be a restrictive provision in practice, but I would be happy to think of it with you, to share your point of view with the practical interest of that condition. Third condition, that there is no equivalent, or that the product is not commercialized or out of supplies. It's the same condition as what we have seen for off-label use. Again, the patients, of course, need to give his consent in writing. Again, the prescription is under the responsibility of the prescribing physician. Again, the prescription needs to wear the inscription prescription for special needs, to let the pharmacist know that he is prescribing a medicinal product, that he will need to deliver a medical product which is not governed by a marketing authorization in the meaning of Article 3, and that he needs to record the importation of these drugs. Again, the physician needs to manage adverse effects. This is under his responsibility. And he will need to have a special insurance for that. So that was for, I would say, the condition of special needs. But there is a second paragraph. In exceptional cases, when the life of the patient is threatened, or in the event of an imminent risk to the life of the patient, a drug without any marketing authorization may be prescribed, subject to points 1 and 3 to 8 of paragraph 1. This means all the conditions that we have just seen, except the obligation of a marketing authorization. This is logical. And there is also 4 additional conditions for the application of this paragraph 2, which is, like I said, the complete absence of marketing authorization. The project of law say that the prescribed medicine does not have a marketing authorization in the European Economic Area or in the signatory country with the European Union. But the medicinal product is manufactured in the European Economic Area or in a signatory country. The benefit-risk ratio of the prescribed drug is presumed to be positive following a critical evaluation of the data acquired from the science. And but that's under the responsibility of the physician to make this benefit-risk ratio, and the prescription needs to mention the prescription, very basic, and to contain any relevant information for the pharmacist, and the pharmacist will need to record the importation of these drugs in a specific register kept for this purpose. Just a few minutes, I have battery issues. Okay, I'm sorry, I apologize. So we've seen the case of a prescription of medicinal product for one patient, and we will go now into the prescription of compassion. The setup, it's not a prescription, it's the setup of a compassionate use program. So what does the project of law says? That the minister, following the advice of the National Research Committee and the Direction of Health, may authorize the establishment of a program relating to the provision for compassionate reasons of drugs for human use, without a marketing authorization, and this will be called program under the following condition.
Camille, we have also a comment regarding your previous slide and the insurance liability for HCP. Do you think that it could discourage the usage of off-label use in practice?
Of course, it is now a legal provision to have the liability insurance. So before this project of law, until there is no legal provision, it's only the practice that admits the off-label use, and there is no obligation to have this insurance. But since it will be mandatory, because it's mandatory under that project of law, a prescription very basically won't be allowed to prescribe off-label use of a medicinal product. So it's not that he will not be encouraged or be discouraged, but in my opinion, he will just simply not be allowed. So that's why it would be very important point to maybe have contact very fastly for with the insurance association to see if there is something to set up in that field. But it's a very important point, and it's in my opinion very important for the patients, because as you may know, insurance are very have a very restrictive interpretation of their condition for the insurance, and I won't be surprised that in the case where there is a damage resulting from an off-label use without an insurance expressively covering this kind of use, the professional could be not, this damage could be excluded from the insurance coverage. So I think it's a very important point, and that's why the legal provision was that important.
And a second question is who covers the cost of the off-label use of the products?
Yeah, that's a very important point. There is currently a provision, I think in the law, but for sure in the status of the CNS. But for sure there is a provision that that states that the reimbursement of medicinal product is subject to the observation of the RCP, the résumé caractéristique des produits. So for the moment, according to that provision, the reimbursement is subject to the respect to the observation of the marketing authorization. But I know from discussion with the CNS that they, of course, apply a kind of flexibility in that field. And since a prescription until a prescription today does not mention for what kind of indications the medicinal product is prescribed, there is a way to avoid the strict observation of this provision. But of course, the CNS is aware that this provision stating that reimbursement is subject to the strict respect of the marketing authorization will need to be adjusted, amended, or there should be an exception. So that's one of the adjustments that I exposed at the beginning of my presentation. There still need adjustment, in my opinion, for the complete execution of this law. But we hope, industry, patients, hope that the cost of the off-label use of the product will, at the end, be covered by the CNS in the same condition as a medicinal product prescribed in the scope of its marketing authorization. That should be the ideal situation. Then I'm sure we will go forward in that direction. The government will go forward in that direction. Is that okay? Did I answer the question?
For me, it was clear. I have no more comment. Who will define the price? And
but the price is defined by the Ministry of the Social Security in Luxembourg. The price, because we are talking about off-label use, the price is defined as a normal medicinal product. The same way, you need to file an application for the approbation of the price to the Ministry of the Social Security, and the price should be approved before any commercialization. And the price is approved here in Luxembourg by a reference to the price applicable in the country of origin of the medicinal product. So at the end, the way of approbation of the price and reimbursement should be the same as a normal medicinal product, as any medicinal product here commercialized here in Luxembourg. Regarding price and costs for the product, we will see that there is a huge difference for a compassionate use program. So I will enter into that subject. So as I said, the ministry can authorize a program for compassionate reasons. So this time, there is a need for a formal authorization issued by the Ministry of Health. What we have seen just before regarding off-label use and prescription without marketing authorization for one patient, it's only a prescription and the condition for the prescription of off-label or without MA. And in essence, the prescription is placed under the responsibility of the physician. Point. Here, the program needs to be formally approved. So it's a complete different framework. So regarding the cause of the program, the cohort of patients, a program can be set up for a cohort of patients who suffer from a disabling, chronic or severe disease, or an illness considered to be life-threatening to the patients in the group. To understand what is considered as a disabling, chronic, severe disease or illness, life-threatening illness, you need to refer to the EU guidelines on compassionate use of medicinal products. Regarding the delivery of such products, the prescribed drug is dispensed by a pharmacist from a pharmacy open to the public or a hospital pharmacy on the basis of the prescription mentioning the inscription compassionate use program. And again, the same obligation for the pharmacist to record such prescription. So contrary to the other provisions, so in that time we are in the case of a cohort of patients, and we saw that the medicinal products can be delivered in a pharmacy open to the public as well as in a hospital. Again, there is no equivalent or not commercialized or out of supply product, and no equivalent with a marketing authorization, of course. And any therapeutical alternative, the cohort of patients cannot be satisfactorily treated with a medical product with a marketing authorization. Important condition, the individual patients forming part of the group of patients covered by the program have not qualified or have withdrawn, as the case may be, from the ongoing clinical trial on the investigational medicinal product used in the disease for which the program has been set up. So this is an important provision. The patient is prohibited from being part of a ongoing clinical trial regarding the medicinal product. But it seems that the condition of ongoing clinical trial is a mandatory provision. So the prescribed medicinal product is manufactured in accordance with the standards of good manufacturing practice, of course. There is a positive balance of risk, nothing surprising. It's again placed, the program is again placed under the supervision of a doctor responsible for the program. The patients, the consent patients, of course, is very important, and always the same condition. The patient needs to give his prior, free, and informed consent in writing. And what could be in practical difficult is that the cohort has the program can be set up if, because it seems to be a mandatory condition, if the cohort has access to the prescribed medicinal product during the period covering the granting of the marketing authorization and the actual placing on the market of the medicinal product provided that the program ends with the granting of the marketing authorization. So there would be attention must be paid on the availability of the product during the duration of the program. Who needs to file the program authorization application? The answer is here. This is one of the conditions: the marketing authorization holder, the manufacturer, the importer of the medicinal product, or the doctor responsible for the program sends the program authorization application to the minister. The content of this application is described in paragraph 2 of the law. And again, there is an obligation to have a civil liability insurance, which covers the risk and damages or loss related to the execution of the program. Just a few words on the program authorization application. So as we just saw, it needs to be filed by the marketing authorization, the manufacturer, the importer, or the responsible doctor. This application needs to be accompanied by a draft program with the objective and the rationale of the program, a complete description of the product. And at the end of the program, there is an obligation to write a report for the minister. And that's important regarding the cost. The medicinal product is free for the patient. And so I think this statement needs more precision in practice, but the product is free, at least for the patient. Regarding the administrative proceeding, advice from the National Committee of Ethics and Research is issued before the authorization of the program, and the duration for that is 45 days from the application. This is the deadline for the advice from the National Committee of Ethics and Research. I did not see in this project of law a deadline for the ministry to authorize the program, but I'm pretty sure that they will be very reactive as usual. This is just to have a brief overview on all these measures that I've just described. So regarding off-label, we have the possibility for the case of individual prescription, international health crisis. I will just detail it in a few minutes. I raised a few questions that I would be happy to think of it with you. Is there a need for a collective prescription in the case of label? Because this is not, I know that it exists in French, but it apparently is not possible under the current project of law, but is there a need? It should be important to assess whether there is a need for such a provision. And in the case of absence of marketing authorization, we saw that there is a possibility for an individual prescription in the case where there is no marketing authorization within the meaning of Article 3. So maybe it could be interesting to assess whether this is a limited practical scope, because we know that most of the authorization, most of the medicinal products authorized in Luxembourg have an European centralized authorization. It could be interesting to think of the link with parallel importation in that case. So that's it. That's for interrogation that I found interesting to raise and to discuss with you if you want. Maybe I can read the question.
Okay.
So,
yes, we have a question, and the question in Belgium, we have the option to set up a medical needs program cohort to provide patients in need with medical products with a market authorization, but for which a new indication is under investigation. Will this exist in Luxembourg as well?
yeah, that's a good question. So this won't be considered, if we are talking about a cohort, it won't be considered as a off-label prescription for one patient, because it could be a off-label prescription, but according to the project of law, it's only for the case of individual prescription. So is it it's an interesting question. I'm not sure in which category it will fall. And it's a medical need program to provide patients with in need with a medical product with the AMA, but for which a new indication is under investigation. Yeah, that's an interesting question. Maybe through it could be possible through the provision regarding off-label use. I think that would be the best option, but maybe I could think of it later and come back to you if you want to send me an email, and maybe we can discuss on that very interesting question. But I will be on the side of label use, probably, because we need to find the best way and to adapt with the current, with the legal framework. But of course, I think there is always gray area and always a material for the discussion with the ministry. If I just come back, so as I said, there is a provision for which covers the case of international health crises, which allow both off-label use and absence of marketing authorization use. And this provision has already been adopted by the law in July 2020, thanks to COVID crisis. But I will just have a few words on that provision, because maybe you are not familiar with. So the purpose of the provision, and this will explain why it has been adopted so fastly during the crisis. The article aims to introduce a new article in the law in order to give the means to respond to a possible re-emergence of COVID through medical countermeasures that are not allowed yet. COVID-19, sorry, through medical countermeasures that are not allowed yet, or that therapeutical indication does not cover COVID yet. So this is a provision that implements Article 5, Paragraph 2 of the European Directive, and is inspired by a Belgian law on medicinal products. So these provisions concerns the case of serious cross-border threat or public health emergency of international concern, which is completely the case for COVID-19. And in that case, the minister may authorize the acquisition and delivery for storage of a drug that does not have a marketing authorization in the Grand Duchy of Luxembourg, more restrictive than the previous authorization, that it's not an authorization under Article 3, but an authorization in the Grand Duchy of Luxembourg. The minister may also authorize the temporary use of a drug that does not have a marketing authorization in the Grand Duchy of Luxembourg, and he may also authorize off-label use. So they wanted to cover a wide range of situations and to be allowed to have the means to react very fastly to such a serious crisis. This provision, contrary to the other program and off-label prescribing that we have seen, there is an express exclusion of civil and administrative liability of the marketing authorization holder, of the authorized manufacturer, of the importer, the wholesaler, the physician, the pharmacist. There is a complete exclusion of liability for all the consequences resulting for the marketing and the use of the drug without marketing authorization or off-label, provided that it has been authorized by the ministry. And this liability exclusion applies regardless of the fact that an authorization has been issued or not in a member state by the European Commission or by the Ministry of Health. So this exclusion applies in any case, but important, liability for defective products remain applicable. So there is no gray area, I think, in that field, and that's why it's very important to have clear and complete legal provisions in our in Luxembourg, in our practice. So we now finished with the question of label, prescription, and prescription without authorization. And I will run into some very basic provision that are in the law. I told you that there is a provision regarding ex-officio authorization. What is it? The project of law will add a new article in the law stating that in the absence of marketing authorization or application filed for medicinal product already authorized in another member state, the minister can allow ex-officio, this means from his own initiative, the marketing of a medicinal product for duly justified public health reasons. This is absolutely not new because this provision already exists in a Grand Ducal regulation, very important regulation of 1992 regarding the commercialization of medicinal products. But as I said, there is it was again a means to fix a lack of legal basis, because this needs to be provided by the law and not by a regulation. So nothing new. This is a purely technical provision, but it's important to know where to find information and just raise a possible improvement of the current framework, because the ministry will need to avoid redundancy and will need to withdraw this provision from the regulation. But let's see if he has the possibility to do so. Regarding the expert commission, and that's the last point regarding the law and on the commercialization of medicinal products. As you may know, any marketing authorization application is subject to the advice of the expert commission. This is provided by Article 18 of the law. And the project of law grants this commission with a new competence, which is to make proposals in relation to questions relating to the marketing of medicines. In French, it's question ayant trait à la mise sur le marché des médicaments. It's a very wide competence. I'm not sure to understand what it will cover in practice, but again, let's see if there is any execution methods to help us to better understand. Well, we finished with that important part of the law. We still need to have a look at 3 additional points. So if you remember my first draw, I showed the different areas that were concerned by this project of law.
Maybe I will launch the last survey just to let Camille breathe a bit. And I will not share 3 different surveys just on medical device. Are you active in that field? And are you familiar with medical devices? I will not spend too much time on that, but could be also an important insight for her. Yeah. So let's share the results. It seems that quite a lot of you has medical device activities with 40%, and also familiar with 1 on 2 has a familiarity with medical devices. So thank you very much for answering this last survey premise.
Regarding medical device, there is nothing very revolutionary. Nothing very substantial. It's a modification of the law of January 1990, which will very likely be amended also thanks to the adoption of the regulation in the field, the European regulation in the field of medical devices. But for now, the project of law just modifies Article 1 of this law to give a legal basis for the commercial margin of the pharmacist who delivers medical devices. So it's always a technical question of legal basis. But if, unless I'm mistaken, there were no provision on that question, even not in any regulation. So it's important that it is in the law that the commercial margin of the pharmacist could be up to a maximum of 50.20% of the purchase price, and of course exclusion of medical devices with a recommended price in Luxembourg, and this would apply in pharmacy open to the public as well as to hospital pharmacy. So that's it for medical devices. There is also a very slight modification of the law regarding the profession of a pharmacist. The project of law modifies an article of this law to give legal basis for the calculation of the fees for the pharmacists providing on-call services. So it's again a very technical aspect of the law. And last point, probably more important because it is related to the distribution of medicinal products, and especially the wholesale distribution of medicinal products. There is a modification of Article 1 of the law on wholesale distribution, which intends to allow wholesalers to distribute medicinal products to doctors, dentists, veterinary, National Center of Firemen, and state services, and also to distribute compound medicinal product to the same person, and in addition to patients at their private premises and residents of senior centers. So that will be new. That's one of the new competence of the wholesaler that we already talked about. So I arrived to the end of my presentation. I hope it was clear enough to let you understand. I think it's not easy to fully understand all the provision of that law, but at least to have a clear overview of the area that will be concerned by this project, and that maybe you have ideas about what should be improved, discussed with the ministry, and maybe you have practical questions, etc. If you have any question, please feel free to ask now through our chat, or later through my email address that you can find just here on that slide. And I thank you very much for your interest and your attention.
So thank you very much, Camille. I think we have room to discuss or brainstorm already if our members has question, or first I will say topics or insight to share with colleagues, and because it's really important to have a common point of view, I think, for the industry. I saw some question. Yes, we will share the slide deck, and also we will post a recording of this session on APL YouTube channel. Do we have, and we will also share with you another survey, but just to know if you have, do you have some question or some remark that you think that APL needs to carry on to the authority, feel free to also share during this, on this request you will receive during the afternoon. No more question, remarks.